Would you just summarize where we're at?
We're live.
No. Thank you.
We just got live. We weren't before.
Eric?
Senators, I think we're in the process of trying to, did you get the email yet, Peggy?
No.
We're in the process of trying to get the document out, but in the meantime, I can tell you that there really are only two very minor changes to the previous version that you looked at. And that would be if everyone saw on page 3 of their previous version, which was 5.1. And that, you remember, that's the addition of offenses to the Big 12, and in particular, it's dealing with the violation of condition of release offense. And it's a change from the words has been to the word is, so that it would provide that that a violation of condition of release would not have to be filed in the criminal division if the proceeding is the subject of a youthful offender proceeding. Essentially, if it is, not has been, but is the subject of a youthful offender proceeding, then the violation of condition of release would be filed in the family division rather than the criminal division, which makes sense because the youthful offender provision is itself in the family division, and the whole idea is to try and keep these motions and the underlying case in the same court. So that change has been to is for that reason. The second change was on page, or is on page 13, and this has to do with the community violence prevention program. And so that will read, it was a clarification that I think the committee wanted to be sure that at least the applicant for the grant was a Vermont entity, so that a Vermont entity could contract, or in other words, work with an entity that wasn't necessarily Vermont, but that the applicant was a Vermont entity. So the language will read, a Vermont municipality or nonprofit organization may submit an application. So those are the two changes. In the that looks like my phone's staying up. It's my computer, right?
Eric, can I ask? Yes, it does. Do you want me to grab it for you?
I think I can get my email right here. I just wanted to thank you. I was able to enlist Ben Navagonsky and Rebecca Turner also did a little while I was rewriting the bill. So I'm looking into the term carrying, I think is what another issue that the committee asked us to try and do a look at. And I think that it seems to be that it probably would be interpreted broader than having to have it on your person. That at least if it's consistent, for example, with constitutional carrying requirements, that at least within your reach or within your possession. Speaking of, thank you so much.
Eric, can I ask you?
So head notes, that one case, and then there's that case, it's like the second circuit. And to the rest.
Yeah, that's it. You were, thank you very much.
Yeah, no
Appreciate
problem.
it. Yeah.
Eric, can I interrupt for 1 second? Can
And,
you take that down?
Oh, right.
And also, you're sure you sent it to Tony, right? Because he said he hadn't received anything yet either.
Yeah, I sent it.
Okay, it's probably just taking a long time.
Right. And unfortunately, I don't have that in my word.
And Eric, there's some highlights in there that'll direct you to the language.
Thank you much, Ben. Appreciate it.
He said he doesn't have it.
Well, I'm just gonna stop sharing the screen then because I don't have it. I don't have the.
Thank you.
Okay. So,
Ben, sorry, go ahead, Senator Sears.
well, I can't ask for a vote when we don't have the bill in front of us. So,
In the interim, I have a question or two, Senator Sears.
sure, go right ahead, Senator.
On page 9, I'm trying to wrap myself around lines 10 through 12 that applies to 7553A. And when I look at Title 13, 7553A, and we all know after many explanations as when bail can be used, how does this 3 lines pertain to what it's telling us in 7553A?
I'm sorry, Senator. I was trying to look at the scary term and I didn't catch your question.
Page 9, lines 10 through 12. not that I condone defacing serial numbers or straw purchases, that's not what I'm saying. But my concern is in looking at those three lines, then it refers to 7553A of this title, and I'm looking at that. And we've had several explanations as to when bail applies and so on and so forth. How do those three lines even come close to 7553? And the same applies for the straw purchase. It clearly says against violence against another person, blah, blah, blah. I mean, it just goes on and on and on, Eric. I'm trying to wrap it around in my mind as to how, just because we say so, I mean, I don't.
Right, yeah, I think that if I'm understanding your question right, that it may be that there are circumstances where the underlying offense didn't track the language in the statute or in the Constitution about it involving violence against another person. Maybe. If that's the case, then I would presume that the person charged with it would raise the defense that it was an unconstitutional attempt to make a violent act, make a non-violent act violent, for example. Kind of understand. On the other hand, there may be circumstances where the defacing of the serial number was connected to some underlying violent conduct. And in a case like that's kind of the distinction I was making earlier, that while it might be unconstitutional as applied to a particular set of facts, there really wasn't any connection between, say, the defacing and any sort of violent conduct. In another case, there might be. And in a situation like that, statute might be upheld as being consistent with the.
Right, but line 10 specifically says conduct constituting the offense of defacing a firearm serial number shall be considered a violent act. It mentions nothing about crimes before or after.
Should we make it may be considered a violent act?
That's an interesting idea.
Still up to the courts. As long as it's up to the courts, that's fine. But what that says and what 7553A says doesn't quite.
And that way, if it's clear in the judge's mind.
I think it gives the judge more discretion that it may be considered a violent act if the circumstances point to a substantial threat of physical violence to any person.
Yeah, I think that's right.
I'd like to read it better on that.
Yeah.
Well, you'd need to change on line 8 and 9 on page 10 as well.
Straw purchases, yes.
And there was also section 7.
Right, it's in those three places.
Yeah.
If the committee's more comfortable with may than shall,
I like may versus shall.
Senator Bowles.
I'm fine with that, but I just want to clarify, this language as it is aligns exactly with federal law, yes?
Well, the underlying offense, yes.
Okay.
But the piece that we're talking about, the fact that it's
The bail piece.
the bail piece,
Got it.
that's unrelated.
Okay, that makes sense. Okay, thank you
Sure.
for just that clarification, but yes, I'm fine with May as well.
all right,
It's posted right now, but I'm still waiting for copies.
Thank you.
all right. Well, we're gonna have other changes, and so let's so everybody's agreed on the mays in those three cases. Okay,
That may
Senator,
resolve the issue with Senator Sears in the sense of, because that's addressing the question of, what constitutes the violent act. If it resolves it in your mind, then it wouldn't be anything, in other words, the language change would be pretty simple.
do you have time tomorrow morning around 10:30, Eric?
Yeah, I think I'm in here on something else at 10:45. I can't remember exactly what. but
Yeah, the forensic facility.
Yeah. Well, in any event, yes, I could make time.
Then could we schedule a vote for tomorrow morning at 10:30 with a final copy of the bill?
Peggy's left the room, Senator Sears.
Oh,
But we can tell her when she comes back.
well, I just got a text from her, so
Oh,
maybe she's still waiting for copies. So she went to get copies. But I'm mindful of Eric's got to be
No, she's
next
just.
door at 11:30. So Peggy, if we schedule a vote on this at 10:30 tomorrow morning,
10:30 tomorrow morning, okay?
Actually, what time is that the break tomorrow for here this morning, or is there a break at 10:45?
We'll check.
the break is at 10:30.
It's 10:30, yeah.
Yep.
So you want me to do the vote and break at 10:45?
Senator Sears?
Yeah.
I'm just wondering, we've got the hard copies in front of us now. I think we have a half an hour. Is there?
Okay. Well, I was worried about Eric having to leave, but
Oh, well, as long, I mean, the change that we have now is just the May, right?
okay, I'm fine with voting now if we can.
Well, I still have questions.
Oh, you do, okay.
Just one. Just one. If I can find it. It has to do with the civil stocking. And I know we voted on this, going to stay in there, but in my reading under, the judge already has the ability to do that. And I believe Eric read that to us. Preponderance of evidence, defendant has stock,
Yep, that's right. Yeah, I think I mentioned that earlier.
The
Yeah.
judge already had the ability to do that, correct?
Under the statute,
Under the statute.
I think. The
But it
statute,
couldn't hurt to reiterate.
policy choice, yeah.
Yeah.
And because they have the authority to do it, that doesn't mean they are necessarily.
Senator Sears, if you would, did that
Yep.
answer your question?
That answers my question. I'm good.
If you would entertain a motion, I would make.
I would. Yes.
On the committee's understanding that those shalls shall become mays. With that said, I would move that the committee report out draft number 6.1 favorably.
Okay,
6.
Senator,
7.1.
Senator Baruth has moved version 7.1 of S4 be reported out favorably. Is there any further discussion? Hearing none, Peggy, could you please call the roll?
Senator Baruth,
Yes.
Senator Norris.
No.
Senator Bihowski,
Yes.
Senator Harshim,
Yes.
Senator Sears.
Yes. I'd like to report the bill, and obviously it has to go to appropriations. Peggy, can you find out how to get it up to Bloomer without my signature?
I can take it up.
Okay, thank you.
So it'd be here. Maybe you can, and then we'll change the reporter the next day. I think we've done that before.
Yeah, I don't think he'll mind if I.
I'd say they've been pretty flexible given
Yeah,
the
I think, yeah,
circumstances.
just switch it. So,
And I think that concludes the work. I thank you very much for all the hard work, everybody, the administration, the Bennington County State Attorney, the Defender General's Office. Everybody's involved in this. It's been a terrific working together. And sorry, it's not a unanimous vote, but I respect Senator Norris and understand his no. So with that, Eric, thank you very much for all the hard work on this.
Yes, thank
Dating
you.
back
Happy
to
to do
last
it.
November.
Right, exactly. Yes.